As most of you, or all of you probably know, the Anti-Social Behaviour Crime and Policing Act 2014 introduced a number of measures that social landlords can use to tackle antisocial behaviour. Some of those measures include anti-social behaviour injunctions and closure orders. The Act also introduced two mandatory grounds for possession of property on the basis of antisocial behaviour. And these statutory provisions amended existing housing legislation. So the 2014 Act introduced Section 84A of the Housing Act 1985, which applies to your secure tenancies, and it introduced Ground 7A of Schedule 2 of the Housing Act 1988, which relates to your assured tenancies. Now, the mandatory grounds are particularly useful to social landlords because if the ground is made out, then the court must make an order for possession of the property, and that is subject to any defence available to the tenant based on his convention rights, so Article 8 or similar defences. But absent a successful convention rights defence, the court has no discretion to not make a possession order, so reasonableness is not considered. The mandatory grounds are also beneficial to landlords because they don't just apply to the tenant, they also apply to the behaviour of other people living with the tenant or the tenant's visitors. So the antisocial behaviour doesn't have to emanate from the tenant himself or herself. It can be someone living with the tenant. And finally, the court's extended jurisdiction to stay or suspend a possession order doesn't apply in mandatory possession cases. If the ground is made out, the court must make an order for possession. In terms of postponement, the most the court can do is postpone up to 14 days, or if exceptional hardship is made out, then 6 weeks. But beyond that, the landlord is entitled to their warrant. So as many of you will know, the mandatory ground will be made out if one of 5 conditions is made out on the evidence. I will take you through the conditions in brief terms. And it's probably worth pointing out as well that the mandatory grounds or the conditions are the same for both Section 84A and for 7A or Ground 7A. So Condition 1 is conviction for a serious offence. In my experience, this is the most commonly encountered condition where Section 84A or 7A is relied upon. Now, the word serious offence has a particular meaning in the legislation, and you can find out whether an offence is a serious offence by looking at Schedule 2A of the Housing Act 1985. That sets out the various offences that are considered to be serious offences for the purposes of these grounds. Schedule 2A applies to both 7A and to 84A. Now, a mere conviction for a serious offence doesn't engage the ground. The offence has to be committed in particular circumstances or against particular individuals. The only other point I would make is that the notice, that is to say the notice seeking possession or the notice of seeking possession, depending on what type of tenancy it is, that must be served within 12 months of the conviction or 12 months of the determination of any appeal against that conviction. So there is a time limit on initiating a claim for possession on the mandatory grounds. The second condition is breach of an antisocial behaviour injunction. This one is also quite commonly encountered in practice as well. I think it needs to be said that it has to be a proven breach. And by that I mean a court has to have made a finding of contempt of court in relation to a breach of an ASB. It's not sufficient to merely suspect that someone has breached an injunction. In order to rely on this ground, you need to be able to demonstrate that they did in fact breach it, and that was proven beyond a reasonable doubt in a court dealing with a committal application. Again, not every breach of an ASB will engage the mandatory ground. Again, the legislation sets out when an ASB breach will engage the ground. And again, all of that's in the handouts. It's worth pointing out that if the legislation is very clear, if it was a condition or a requirement of an injunction that the individual participate in an activity and the breach relates to a failure to participate in that activity, that will not engage the ground. The notice must be served within 12 months of the finding of breach or the committal finding, or within 12 months of the determination of any appeal against that finding. The third one is, or condition 3, is breach of a criminal behaviour order, or a CBO. Again, the notice seeking possession must be served within 12 months of the conviction for breaching the CBO, or within 12 months of the determination of any appeal against that conviction. Condition 4 is a closure order. So in order for this ground to be engaged, the property where the tenant or other individual lives must have been subject to a closure order, and access to the dwelling must have been prohibited for a continuous period of more than 48 hours. That 48-hour period includes any period of non-access under the preceding closure notice. So if the closure notice closed the property for 24 hours, then it came to the magistrate's court within 24 hours' time, and a 48-hour closure order was imposed, we'd have a total period of 3 days, which would engage the ground. The period under the closure notice also counts. But of course, there has to be a closure order as well. So if it was closed for a period of time under a notice, then the application for a closure order was dismissed, then the ground wouldn't be engaged. I think the main point to make about this one is that unlike grounds 1, 2, and 3 and ground 5, the notice must be served within 3 months of the closure order, or within 3 months of the determination of any appeal against that closure order. And finally, on the conditions, we have condition 5, which are convictions under the Environmental Protection Act 1990 for certain offences relating to noise. Now, I've not encountered this one in practice at all. I'm not going to spend much time on it. The only other points I'd make that in common with the vast majority of the conditions, the notice must be served within 12 months of the conviction or within 12 months of the determination of any appeal against that conviction. So having looked at the grounds, I just want to deal with some recent developments in this area of housing practice. The Renters' Rights Bill that is currently going through Parliament, in relation to that bill, it's proposed that the notice period for ground 7A, that is the period between service of the notice and the earliest date upon which the landlord can start proceedings for possession, that's currently, I think it's 1 month if it's fixed term, and the shortest period that it could be brought to an end by a notice to quit in relation to a periodic tenancy. But in relation to 7A, they're proposing to reduce that to immediate, so that if the landlord wants to rely on ground 7A, it will be able to serve the notice seeking possession and start proceedings immediately thereafter. that would bring 7A in line with the current discretionary ground for possession under the 88 Act, which is ground 14. I'm not aware of any analogous amendment in relation to 84A. As far as I'm aware, 84A will remain as it is at the moment, which is 4 weeks, or the earliest date it can be brought to an end by a notice to quit. I think the biggest development for this area, certainly in recent times, is the Court of Appeal's decision in Brent London Borough Council against Hajan and Poplar Housing against Kerr. If you practice in this area and you haven't already read that judgment, then I think it's one you should consider. Now, essentially, in Hajan, the claimant landlord issued proceedings for possession against the tenant on discretionary grounds. During the course of the litigation, the mandatory ground became engaged on the evidence. So the defendant, or the claimant even, served a notice seeking possession upon the tenant. And once that had expired, they applied to amend the existing proceedings to include the mandatory ground. The Court of Appeals said that this was acceptable, that existing proceedings can be amended to include the mandatory ground. In the Court of Appeal's words, the amendment to the proceedings has essentially the same meaning as starting proceedings in relation to the tenant's arguments on notice. The case of Kerr was a little bit more convoluted. In Kerr, it was said that a district judge is entitled to review a suspended possession order in light of current circumstances. And when carrying out this review, the district judge can take account of any material which makes out a mandatory ground of possession. In this case, given that the material made out the mandatory ground, the district judge amended the order, that is to say the suspended possession order, so that it took effect as an outright order. The Court of Appeal held that this was acceptable. If you do propose to amend to apply to the court to amend any existing suspended possession orders on the basis of a mandatory ground, you should still serve the notice and allow the notice to run its course before making the application. I would suggest that this case, and it's a joint case, so both appeals were considered together and the judgment deals with both appeals in one document. It is certainly a document that is worth reading if you are involved in possession cases arising from antisocial behaviour. And a final point, the Supreme Court has rejected both Hajan's and Kerr's applications for permission to appeal. Therefore, we can be certain for the time being that the case I just mentioned is good law and remains authoritative. So I'm going to move on now to the final section of the talk, which is some tips for practitioners. If you propose to rely on either 84A or 7A, then please make sure that the grounds are actually made out. And I say that because I've heard anecdotally in the past that some social landlords have relied on, say, for instance, ground 7A on the basis that the tenant or someone living in the tenant's dwelling had breached an anti-social behaviour injunction. But on further probing, there had been no finding of that. Instead, the landlord took the view that there had been a breach, basically an alleged breach, and mistakenly thought that was sufficient to engage the ground. No, you have to have evidence that the ground is engaged. So you need a certificate of conviction or an order confirming a committal or something of that nature, a copy of the closure order. From a tenant's perspective, tenant representatives should be seeking evidence of the conviction or similar from the claimant to make sure that the ground is properly engaged. The biggest tip, I suppose, is notices. The notices have to be right, whether that's the appropriate notice for 84A or the notice for ground 7A. These need to be compliant. You need to allow the notice period between service and the start of proceedings to run its course. If you give short notice, then the notice seems to me to be invalid and would potentially result or likely result in the mandatory ground being taken out of the equation. In addition, you need to be sure that you're bringing these claims within the limitation period. So for instance, if the tenant or someone else in the household has been convicted of an offence, then you have 12 months from the date of the conviction to serve that notice, or 12 months from any appeal from that. If you don't meet that deadline, then it seems to me that you can't rely on the mandatory ground. This could be potentially a problem in relation to the closure order, because the 3-month period is quite short, so you'd need to move quickly to get that served. I suppose from a tenant point of view, tenant solicitors or tenant representatives need to be scrutinising these notices and exploiting any defects within the notices in order to defeat the mandatory ground. From a tenant point of view, if the mandatory ground can be taken out of the equation, then the tenant solicitor's job becomes a lot easier. Although a possession order can be made on discretionary grounds for antisocial behaviour, there's still more room for manoeuvre in discretionary cases. And if an outright order is made, you can still apply to suspend in a discretion case. So I think notices is a very important thing for both landlords and tenants in this type of litigation. As I mentioned at the outset, if the ground is made out, then the court will need to make or must make an order for possession. But this is subject to any available defence based on the tenant's convention rights. In practice, this translates to public law defences, issues of proportionality, and Equality Act defences. So a tenant may argue that the decision, and public law arguments aren't against the act of seeking possession, they're against the decision to seek possession. So it's the decision making that is challenged in public law defences. And tenants may argue that the decision to seek possession was disproportionate when measured against their rights under Article 8 of the European Convention on Human Rights. Or they may say that the decision to seek possession was a breach of the public sector equality duty if, for instance, there was no consideration of the tenant's disabilities or disabilities of others in the household. Tenants sometimes also rely on the Equality Act 2010. They will argue that the instigation of possession proceedings is discriminatory for reasons related to their disability. Against these types of defences, it seems to me that landlords need to be carrying out regular proportionality reviews. And these reviews need to be in writing, and they need to consider disabilities of everyone in the household. You need to commit it to writing because you'll need this evidence to show that you were compliant with your public law duties, such as PSED compliance or proportionality compliance. You want to deploy those reviews as part of your prosecution of the case. It should go without saying that landlords should approach these reviews with an open mind. Just because a mandatory ground is made out, it doesn't mean that it needs to be pursued in every case. The case has to be looked at in the round, including issues such as disability. From a tenant solicitor's point of view, I think the main points I would make, if there is disability within the household, then you need to prove that. Disability isn't self-proving. You need some sort of evidence to confirm that the individual is disabled within the meaning of the 2010 Act. In relation to psychiatric illnesses, this will almost always mean obtaining a report from a clinical psychiatrist to confirm that. In addition to obtaining expert evidence, tenant solicitors should also be carrying out or reviewing landlords' proportionality reviews, because exploiting defects in those reviews may increase the chances of success on a public law argument. I mean, make no mistake, in relation to these types of cases, the tenant is in quite a difficult position. These defences will only work in a limited number of cases, and if they don't work, then the court will make that possession order.